Today is the second Instagram live of the day, and my hair looks different because somebody did it. Anyway, tonight's guest is our friend, California matrimonial divorce family lawyer, Padideh Jafari. Here she is. I was going to give a whole little intro. Hope this works. I was going to say, Padideh and I became friends like a few months ago,
Hi.
right? Hi. So good to see you. So I am so sweaty, and I have a broken fan that I'm just like, I'm not going to have my hair blowing all over the place. But I was going to say we met virtually a few months ago. I think it was male victims of female narcissists, had introduced us, right? And we really
Yes.
clicked. And then you happened to be in New York, and we met, and then we met again, and we met again, and then you came to our book launch party in New York City, like the jet setter that you are, like flying between Florida, California, New York. We were so honored. And now we're very excited because next week we're going to see you again at your end of the country, West Coast, for our big meet and greet, book signing, book launch party, and several other activities. But we're going to keep putting out the little invite on our stories, but that's not what we're going to talk about now, right?
No. I mean, we could talk about that
Nobody
because
wants to hear about that. They want to hear about 50-50.
I'm excited about having and hosting Lisa and Chris, my good friends, in Southern California, and having them come to one of my favorite spots that I love to go to, which is the Firefly restaurant in Studio City. So for all of you that are interested, please check our Instagrams. There's an invite. It's appetizers, drinks. You get a free book, been there, got out book. I mean, free valet. Everything's free. We're going to be like Oprah, like you.
Well, that's awesome. So we are very, very excited, but that is not what we're going to talk about tonight. So that was the little infomercial. But tonight we are going to talk about a controversial issue that comes up all the time in our community, and that's 50-50 custody, 50-50 access, 50-50 visitation. And I posted a clip from an interview that we did a while ago where we were talking about 50-50, and you were saying that that's what the courts would generally gear towards for ready, willing, and able parents. But that is not the parents that you are talking to right now. I mean, well, hopefully you're talking to one that's ready, willing, and able, but that is not their exes that they're dealing with. So tell us about ideas regarding how to handle custody when you have a very difficult ex partner.
Okay, so my thing is, yes, in California, and my understanding is in other states, courts want to have 50-50 with ready, willing, and able parents, okay? This notion that somehow moms are the better parents, the superior parents than dads, to us, that's considered sexism, and it's just simply not true in 2023. So we know that moms work, they need to use daycare, dads work, they need to use daycare or babysitters. And so in our law firm, we always present 50-50 to our clients. And I want to know the reasons why you think, as my client, that the other party should not get 50-50. And so unless there is documentation to your claims that the other party is an unfit parent, has any type of alcohol or drug abuse issues, has mental illness, there is abuse that's documented, whether it's through police reports, CPS reports, and the proximity, the distance between where you're going to live and the other parent is going to live. I want to see all that, okay? Because generally speaking, in California, especially Southern California, courts want 50-50, okay? And so this becomes obviously a problem when you have somebody that has a mental illness. Now, Lisa, Chris, and I, we talk a lot about narcissism and toxic, abusive type of parents and high conflict type of parents. So I think your question, Lisa, is what do you do in that type of situation, right? Where you have a more stable parent and then you have the other parent who is either mentally ill, is bipolar. They could have, undiagnosed illnesses. What do you do in that type of situation? And we put up a lot of safeguards for the best interest of the child. For example, we had a situation with a high conflict celebrity divorce that came into our office about 6 weeks ago that, the father was just a wide range of illnesses, okay? From, mental illness to drug abuse to just, a, a, a wide range of illnesses, okay? And he was very, very powerful and wealthy in the community. So we had a lot of different factors to consider. And so what we do is we come up with a strategy for our clients. So we were able to get a temporary restraining order. It was right after Memorial Day weekend. So we pretty much worked all throughout the 3 days before Memorial Day weekend. Then Tuesday, when the courts reopened, we filed the restraining order and we filed for dissolution of marriage, which in California is the divorce petition. And so that's how we sort of did that. We asked for supervised visitation. We asked for drug testing right out the gate. And so the other side was obviously not very happy with us because they were saying, well, you're only listening to your client. Your client is saying that there's drug abuse, but there isn't. And my thing is, okay, so prove it. Let's do drug testing. Let's do random drug testing. So all that to say is, this is how we handled this situation.
Okay. I was going to say, now I know you said you asked for supervised visitation. That's often something that our clients hope for, especially when they have children that are really little that can't advocate for themselves and can't take care of themselves. But that sounds like something that's pretty hard to get, especially right out of the gate without some blatant thing that's wrong.
Right.
Tell us about how easy it is to get supervised visitation, especially if the other side is fighting it and saying, what basis do you have? I don't need to be monitored.
Right. Well, here's the thing. You can ask for it initially, but then you also have to prove it. Now, in Southern California, what happens is you can request it. You can request it in the temporary restraining order and in the petition, and then you go before court. And the court's going to say, well, what other safeguards can I put into place? Like, we asked for random drug testing, which we were able to get. We asked for drop-offs at the police station, which we were able to get. So you might not get supervised visitation out the gate once you file, unless there is already documented evidence, right? So let's say if there is a police report or a CPS report already in the works, and then you could say, well, we're waiting for the report to come out, but before it does, because it takes months and months to get that report, let's put this safeguard into place, supervised visitation. One of the things that we asked for was a monitor. So a monitor to come to the police station and just watch everything, because the police, they're not going to get involved, right? And so the drop-off and pickups were at the police station, but then there was a monitor that kind of, took the child from one place, from one mom to the dad, and vice versa. So there's a lot of different sort of safeguards. And, with dad in this situation, he was not able to get overnights, which is a big deal. Like, look, if you want to take your child from 2 to 7, by all means, right? That's 5 hours. We'll do random drug testing, but overnights, like, that was something we were not going to just sign away. And thankfully we didn't have to, because we came up with an agreement.
Yeah, and I was going to say, so this is something that you did outside of court. You did it yourselves. A judge didn't rule on what had to happen. So you had more flexibility?
Yes and no. What happens is you file all the paperwork, and then the judge sort of says, go mediate, right? Because one thing that people don't understand, especially clients that this is their first rodeo, their first divorce. And listen, we have repeat offenders. We have people that are on their fourth divorces. Okay. So
you're in LA. So
them repeat offenders. Okay. So especially if it's your first divorce, people don't realize, and clients don't realize, that judges don't like to make decisions, because a judge, once they make a decision, it can go up for appeal, right? If one or the other party doesn't like it. So judges really like when people can mediate. The problem with that is that if people could get along and mediate, they wouldn't be in divorce court. It's sort of like, Your Honor, so that's the problem. And so we go into mediation, and then it's like a battle of, words with the lawyers, and then the other party, they're like, hating each other, sending each other daggers. I mean, it's a narcissistic circus, as I like to say. Okay. It's like the most toxic place you could be. It's like WWE is safer than being in, divorce court with a narcissist and his narcissistic attorney. I mean, it's like, someone's coming out bloody. Okay. So that's sort of what happens. And so we were able to say no supervised, no, they didn't want supervised visitation, but we said no overnights. And by all means, he wants to see the child 5 hours, pick up, drop offs at the police station. By all means, like, let's go. That's something that we can sign off on. Obviously, you're in a police station, so if the person's late, if the person doesn't show up, you can always make a police report right then and there. And that's how we were able to handle that. We did do the random drug testing. We did have an expert testify that the person was in fact a sociopath. So those are things that we were able to kind of put together in a very short period of time to convince the judge that, yes, there is going to be parenting issues in this case. So that's the stuff that we do to be successful in court.
So you said you had an expert witness testify that one of the people was a sociopath, and that really had an impact?
Right. So because at the TRO stage, right, at the temporary restraining order, we can't bring the expert, like, to testify. We had an affidavit. Some places call it declaration. In Southern California, we call it declaration, from the expert saying, I haven't seen the person, obviously, but like, we sent the person videos and pictures and all that stuff, like, based on this documented 2-month period, this is what I believe to be true. And
that's so interesting. We haven't heard of that before. Somebody like an expert witness who doesn't testify but gets copies of evidence. Actually, we have had something like that, but they didn't diagnose someone as a sociopath.
Yeah, so that type of thing is very helpful to show the court that there's a problem. And, also this person had medication, and we had pictures of all that. We had like hours of videos. I mean, we had a lot of things already that our client had given us to present to the expert. Now, obviously, at the trial, the expert has to come and testify, right? Because both sides are going to want to make sure that what they're saying is true, and so on and so forth. But initially, we throw the whole kitchen sink in there.
So it's like leverage. It sounds like it's leverage.
Even if two things don't stick, the judge is reading like a 50-page document, and it's like, this is high conflict. And that is in fact what the judge said. She actually came out of chambers and said, this is high conflict. And I'm going to order 16 hours of parenting classes for both sides.
Really?
And she has said, if you do the 12-hour class or the 12-week class, I'm going to have you come back and do the 15-week class, because this is highly contentious and high conflict divorce case.
So
And
she had both sides do it, not just one, because she doesn't know, right?
Yeah.
She doesn't know what the cause is because it's still at the very beginning of the process.
Yes. And courts will usually do that. So they'll say, okay, unless it's like anger management or something like that, obviously they're not going to make the other person, go to anger management. That's never, doesn't even have an anger management problem. It's the restraining order is not against them. But generally speaking, any type of parenting classes, they want to see both sides. We asked for our family wizard. There's parenting apps in, I believe, every state. So definitely get on a parenting app, request that. There's a couple different ones. There's Onward. There's different parenting apps in Southern California. So that's something we requested. And the good thing about a parenting app is that the judge, more oftentimes than not, can just jump on there and see the communication between the parents, which is obviously great.
Yeah. All right. So I have a couple of random questions I just thought of. One came up in our legal abuse support group. Court orders, are those confidential? Someone was saying that they might want to share it with somebody else who's involved with their ex to help that person. But we weren't sure if everything was confidential, and we did have a lawyer on who said you got to be careful.
So in Southern California, anything that's like a court order, it's all public. So you can go and look at, let's say, one of my clients' information. Now, there are things that are confidential and are under seal. That's different. Okay. So sometimes people will say, like for instance, DNA tests, those are really, under seal usually. Okay. So, but court orders, as long as it's filed in the court system, it's public. So anybody can have access to that.
But it might be different in different states for that?
Yes, absolutely. Absolutely.
Okay. So our people still need to find out, like double check.
Yes. And in any state that's not California, you need to double check. But I know in California, it's as long as it's filed in the court and it's not something like a DNA test or something of that nature, it's anybody can have access to it and get it even online. So
yeah, that's similar in Connecticut, but financial affidavits nobody can look at those.
Okay. That's not the case in Southern California. You can get, yeah. That's why, if like we have a lot of celebrity divorces, that's why we do everything through mediation and, mandatory voluntary settlements and things of that nature. So it's not filed in the court system. It's just a document between the parties, and then that gets, the judge signs it, but it doesn't go through the court system, and you usually get a private judge. So it's not the sitting judge in the court. So it's a little bit complicated, but we have to be, very careful with the celebrity divorces because they don't want people to know all of their finances.
Yeah, so that's interesting because we also think about leverage in terms of it's better for us to keep our information in these private rooms than to get it on public record.
Yes. And, that happens, right? So in this one case that I'm speaking of, they wanted to keep it private, but we actually wanted it, not to be private. So, depending on obviously what side you have, so, and, it is what it is, right? So don't do.
Let me ask you about that. So if you didn't want it to be private, how does it help your client to, let's say, expose a public figure?
Well, listen, there is this notion of the public court of opinion. I'm sure you've heard of that. A lot of actually not so much divorce lawyers, but a lot of criminal defense lawyers will do that. Well, they'll say, okay, it's the court of public opinion. And so they'll do these interviews to make their client look innocent. Like, look at all this charity work he does. Like, or what, look at all the stuff she does, you know, blah, blah, blah. So lawyers, divorce lawyers are, you know, more careful about that. Obviously, we have TMZ calling us almost weekly. We don't comment on those types of cases and those types of like these, you know, bottom feeders or whatever you want to call them, for lack of a better word. But, you know, generally speaking, we want to make it public because we don't have anything to hide. And sometimes with these narcissistic abuse, sociopathic, toxic, abusive cases, what happens is the victim has been so victimized throughout the relationship that this is the first time that they actually have a voice. And so they want to use that voice and say, wait a minute, I have no obligation to keep this public, you know, to keep this private. Why do I have to go to a private judge to have a decision? No, I want to make this public. And so that's where we were on in this case. And we said, okay, you know, our client is pretty much king and queen in our law firm. Now, some attorneys don't view clients like that, but for us, it's like we do, as long as it's legal and within the bounds of the law, our clients are kings and queens. So it's like, okay, you want to make it public, by all means. And if the person doesn't want to, you know, wants to correct their you know, their behavior, then great. They have nothing to hide. And so
Right. How often does that happen though?
I use reverse psychology. Well, I think with narcissistic divorces, these high conflict divorces, I think they could be on their good behavior, right? Because they're actors. These narcissists are actors. They're nothing more than actors. Okay. So they could be on their good behavior for a short period of time, but that mask falls off in family court just like it does in their private homes. And so once it falls off, it's like game on, right? And then it's like, oh, look, Your Honor, look at what he or she said in the app, you know. And
Right.
then,
Satisfying.
you know, yeah, it's like, okay, I'll just, you know, what one person said to me the other day, well, why don't you just, you know, this person on from the other side was like emailing me these crazy emails, and this lawyer said, well, why don't you just block him? And I was like, why? He's like, he's shooting himself in the foot. Like, wait till I tell the judge that this guy has his own lawyer, but he keeps emailing me. Why would I block that? That would be like shooting myself in the foot. Not that I'm triggering anyone, because we have to be careful. These people have mental illnesses, so we're not triggering them, but we're just allowing it to play out just the normal way that it would play out with a narcissist. You know, they're so.
I mean, we say that too. They dig their own grave. They just let them keep going.
Yeah. And yeah, somebody's saying, you know, the covert narcs, are they a bit more deceptive? They are just more deceptive, but within a divorce situation, which usually takes 6 months, 9 months, a year, 2 years in Southern California, at some point, that mask is going to fall. And when it falls heavy. Okay. And we get to see it. I mean, I don't know if Lisa mentioned this, a psychology background. I worked for the district attorney's office in the child molestation and abuse division. I've clerked for judges. I know for a fact that mask is going to fall. Now, I'll be patient. I'll give you 90 days to act correct, but that mask is going to fall at some point because they're not going to get what they want. And as soon as they don't get what they want, they go get a new attorney. That's the first thing that they do. And then all of a sudden, you know, we just keep telling the judge, and we file these things called 271 motions, which are actually requesting attorney's fees from the other side. And so we just kind of, you know, constantly try to, you know, trap them in their own little circus. Priscilla is saying when it falls heavy. Yes, it does. Yes, it does. It falls heavy. how do you recommend exposing messages on Our Family Wizard? So that's not hard. What you can do is you can ask your attorney you can give them authorization to view the Our Family Wizard, and then they can download it. We have a different app than you guys have. It's a professional app for Our Family Wizard. They can download it and then attach it as an exhibit to a motion to show the judge. And the judge can see it too. So the judge can log on and see it. But you kind of have to request it from the judge. They're not going to go, okay, so-and-so's in court. Let me go look at Our Family Wizard. So you just have to request that the judge go see it.
Yeah. Okay. So another question that I was thinking of that seems to be a theme recently is, well, not just even recently, but when people are trying to figure out an access schedule and you know that there's emotional abuse going on toward the children, is there anything a parent can do, or even after the parenting plan's in place, they've already gotten divorced, years are passing, and there's all kinds of cruelty from the other parent to the child? We have a lot of situations where our client is like, what can I do? I want to write to my ex and call them out, but then there's the thing of like calling them out, then they're going to see that it upsets you and it's not going to change. Like, do you have any ideas on how to handle that with the hidden abuse for most people, the emotional abuse from a parent to a child, and the other parent is aware of it and is like, I feel stuck?
Right. I mean, here's the thing. There is a fine line. Okay. So sometimes clients will say it's emotional abuse. And I'm like, well, what is that? What does that look like? Because emotional abuse to you might not be emotional abuse how the court views it. Do you see what I'm saying? And
Yeah.
emotional abuse is very hard to obviously document as opposed to physical abuse. So for emotional abuse, I would get the child a therapist, because every judge is going to say yes to therapy. Okay, so get it at a child therapist. Then the child therapist can come and testify in court to say, yes, Johnny XYZ, but if you're saying it yourself as a parent, then you just look like a lunatic, because they're like, well, what do you mean by emotional abuse? And let's be honest. Listen, I love family court, okay? I'm going to be a judge someday. I have no bad words to say about family court. But we also know that there are judges that just don't care, right? They have 40 cases on their docket a day. They're like, what do you mean by emotional abuse? Like, it doesn't mean anything to a judge unless it's documented. So for emotional abuse, I would suggest a therapist for the child. Now, if you are going to therapy, make sure that your therapist is different than the child therapist. Some people do,
Good to know.
and I'm like, what are y'all doing? Okay, so make sure that the child has their own therapist. And if you have multiple children, they can go to the same therapist. That's fine. And then the therapist can testify in court to the judge and say, Johnny says that when when he is with dad's just playing video games and not spending time with Johnny. And the judge will be like, really? But the dad's asking for 50-50. So do you see, this is how this can play out in court. If it's physical abuse, then that's a little bit easier to document, because you can go through the hospital, you can go to an ER. If it's really serious, they will call Child Protective Services. We are not big fans of Child Protective Services at our firm. But, obviously there's Child Protective Services. You can make a police report. There's various things. I just would caution you that this notion of emotional abuse, what you may think is emotional abuse, may actually not be really emotional abuse. Like you're saying, well, all the dads take their children on vacation. All the dads take their children to soccer practice. That's not emotional abuse. Okay. So make sure that when you're using these words, there's actually documented abuse by a therapist who is saying there is emotional abuse.
So third party. Okay, here's another thing that comes up all the time. People have legal decision making, joint legal decision making. So they They both have to decide on medical, for example, including mental health.
Yes.
Our client says our kid needs a therapist. The ex says, nope, 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 nothing's wrong. I'm not going to send the kid to a therapist. Right. And our clients are worried. They don't want to unilaterally make the decision because they feel like it could bite them in the butt in court. So what do when they see their kid really, really needs help and the other side won't allow it?
Well, I would just say go and get a motion through the court. Ask for therapy through the court. I have rarely ever, I don't think I've actually ever seen a judge deny therapy to a child. So if you make that motion, and you could write a letter to the other person, the other spouse, and just say, or the other parent, and just say, these are the issues that I'm seeing. I'm not a therapist. Okay, so put that out there. I'm not a therapist. These are the issues that Johnny is having. And, if you don't agree, then I'm giving you notice that I'm going to enlist the child. If you don't agree, then file in court, or I will file in court. And a lot of times people don't want to file in court because it's too expensive. Yeah. So, just make sure that you put that in a letter or an email and just say, these are the 5 things I'm seeing Johnny is having problems with. Also, don't forget there's therapists in schools too. So you could get like a child therapist in the school. You could get a principal. There's all these different people that, and if they don't agree with you, screw it. You're the parent. Like, write an email, and then at least you have it documented. So if they take you to court, you'd be like, Your Honor, this child is having mental issues, and a lot of kids have mental issues because of the divorce. And
right.
That's something that they can do, and never, ever deny your child therapy. I mean, that's just goes without saying. That's, we suggest therapy for our boys, and our boys are 24, 21, and 19. And because my husband went through a grueling, high conflict divorce in New York, we suggest it all the time. And our kids have been in and out. And so, sometimes when they're younger, they're like, that's not cool. And it's like, no, it is so cool. You get to go talk to someone, and it's not mom and dad, and it's not stepmom, and it's not, and so, and they're really there to give you the tools that you need, and we say, well, we're not going to put this on you or pressure you, but just know it's available if you need it. And so we have had them reach out to even just the school therapist, because they thought that was more comfortable for them than an outside therapist. Priscilla saying, my daughters love therapy. Yeah, it's just like, therapists, if they're good, they can make it fun.
Yeah. And actually what you're saying about reaching out to the school, I just interviewed a school psychologist a couple of weeks ago who said exactly what you're saying. She said, often if you can't get a private therapist, go to the school. That's where your kid spends more time than anything. And that doesn't seem to count the same as going to get private therapy.
Correct. And then if the school therapist says, Johnny has a problem, then they can call the other parent. And it's not like you saying it. It's the therapist saying, no, I'm going to be suggesting this, and I'm going to give a letter, affidavit, or declaration to mom or dad, whoever. And so I suggest you take your child and I mean, imagine if they're saying that your child needs therapy, but
right, neutral third party.
Yeah, but a lot of times narcissists, they don't want to put their children in therapy because they see that as a weakness to them, because everything is a reflection of them. And so they'll be like, oh, well, this person's perfect. Mind you, they're failing. But, and they're having, they're peeing in their bed and they're like 18. But it's like, no, they're perfect, because I'm, a perfect mom. And it's like, no, you suck. And so that's kind of how that plays out. I always have to laugh at these lies, because otherwise it's too serious, guys. I'm sorry.
No, it's fine. Okay, here's another thing you just touched on, which I know is a very big issue for some of our clients. They have a custody agreement, and when the kids go to the ex's house, that person does not spend time with them at all. They have a nanny constantly. the kids hate the nanny. They spend more time with the nanny than either parent because they're always with that one nanny at that one person's house. And so I'll just say one of our people in particular is really upset about this and thinking about changing custody, but I know it's one of the custody factors, but it just doesn't seem like enough. What do you think about that when the other person does not spend time with them, just has them in childcare or with another person besides them on their access time that they fought really hard in court for and then just gave it?
And people fight a lot in court that are toxic and abusive and narcissists, not because they want to spend time with their child, but so they can like bring the child onto social media and go, look, I have 50-50 with my child, or somebody does it so they don't pay child support. I mean, these parents are not worth a damn, okay? But how do you prove that in court? You're going to, again, have to have a psychologist or psychiatrist, somebody with the child. That person has to say to the court. You can also ask for a child custody evaluator. We're asking one in one of our cases because we have a similar situation with a 1.5-year-old where dad is not spending time with the child, does not want to give child support. It's evident. And then is saying, I want 50-50. We're like, with who? With the dog? Because it's not with your daughter, because you're actually not spending time with the daughter and your mom is watching the daughter. And how do we know this? Because we know it, right? Like there's ways that moms are like little FBI agents. They figure things out, right? Especially these mama bears or tiger moms. So it's like we can tell, and so we're asking for a child custody evaluation done, which is expensive, it's lengthy, but that's what I told the client. It's like, okay, well, you're making these allegations, but it's going to cost you because now we have to go to court and get a requested child custody evaluation. And by the way, the attorney for the dad is saying absolutely not. He's like the perfect father. Like when you see father, when you see father in the dictionary, it's his picture that you see, and it's like. And I always say this, and I really should say it again. Narcissists and toxic people find narcissistic and toxic attorneys. And in divorce court, they are running rampant, okay? And so they're part of the circus and they're running around. I'm writing a book, and one of the chapters is called The Narcissist Circus. And so these people are part of the circus, and they're just kind of doing, they're like the flying monkeys of the narcissist. They're like, you want to file something, I'll file it for you. Like, it's totally frivolous, but I'll file it for you. And so we're not that type of lawyer, absolutely not. And we actually try not to file. We try not to do ex partes and emergency orders. Sometimes obviously we have to, but we don't like to do it. We try to be amicable, but sometimes you can't with these narcissistic spouses and their attorneys. And somebody's saying, is it difficult to change custody agreements if the child reports they never see the non-custodial parent, or if they don't want to go? Look, there has to be a material change of circumstance in Southern California. Every state has what that means, their version of that. Okay, so again, how do you prove that? You have to get a therapist or a psychiatrist for the child, and they need to come and testify. And if you can't afford that, then just go through the counselors that each school provides. And believe it or not, they do provide them for your child, and then they can come and testify, or they can make a recommendation of who you should use. And so that's the best way. But you just going into court, it's going to be your word against the other parent. And judges don't like to make decisions on this. They don't like to change custody. So you're going to have the burden of proof. And how are you going to do that if it's he said, she said?
Yeah.
And just so you know, in Southern California, children do not testify in court. They're incompetent to testify until they're 18 years old or over, which, that's, child, the jurisdiction of the court ends at 18. or 19 if they're in high school. So there's that exception. Or if they are a special needs child, then it can be extended, but they're not competent to testify. So either you have to get a therapist, a child custody evaluator, or minors counsel. That's like the third way that you can, obviously also CPS worker, but we don't suggest going that route.
So the kids don't testify in court directly, but we've heard of a number of cases where judges will ask kids to go into chambers. How common is that where you are?
I'm not going to say it doesn't happen, but it happens very, very rarely.
Okay. All right.
I wouldn't hang your hat on that. Like, I wouldn't be like, oh, well, Your Honor, would you like to interview the child? No, they're not going to want to interview the child. They're going to be like, that's not my job. You're making me do the work, and you as a lawyer have to do the work and then present the evidence to me. So that, there was a funny article about Sharon Stone, and we actually helped with that case, and she was saying that, oh yeah, the judge said XYZ and interviewed my I'm like, that never happened. Like, file that under things that never happened in the Sharon Stone child custody case 20 million years ago. Okay, I have no idea why this woman is talking about it today, but it is absolutely did not happen. So it upsets me when people do that, because then it feels like, oh well, judges are interviewing kids these days. It's like, no, they don't do that. So why even saying that? So anyway.
Yeah. So there's a question coming in, and I'm going to use part of it to ask another question. So we mentioned a guardian ad litem or custody evaluator, and then there's also attorney for the child or minors counsel. They have different roles, yes, right? Guardian ad litem is someone that decides child's best interest, but attorney for the child, where we are in New York, does what the child wants. Do you have an opinion on which is better? Because someone is mentioning that they have a 10-year-old who is being alienated, which we also know, controversial topic, parental alienation, also called abuse by proxy. Yes. So if that child is being turned against the other parent and then gets to say something, like, what would happen if they talk to a GAL versus an attorney for the child? So, again, 10-year-old.
Yeah, so we don't have that in California. We only have minors counsel, which is the attorney for the child, and then we have the child custody evaluator. So, this person's saying is a DV, victim of a DV, and the husband is alienating the child, haven't seen the child in 5 weeks, is asking who he wants to stay with. Who he wants to stay with is really not relevant in California. So, they would have to go to a therapist. The therapist would have to come and testify, or the child custody evaluator. So, I don't feel like going with mom or dad is like of no consequence in California. So you have to see, if you get a child custody evaluator, what are their recommendation to the court, because they will come and testify. And then also getting minors counsel, which is the child's own attorney, right? So they can advocate for they do advocate for the child, but everyone really wants the best interests of the child, but nobody knows what the heck that means, okay? Because it's like the most vaguest. It's like saying reasonable. Like somebody says, well, what's reasonable? Because what's reasonable to Lisa is not reasonable to me, right? And so vice versa. So that, child's best interest is, you have to kind of, it's one of those things. It's not black and white. So my suggestion to you is to get a child custody evaluation, get minors counsel, and if you can't afford that, get the child at least in therapy, but you haven't seen the child in 5 weeks. But you can ask the court to, force the other parent to put the child in therapy, and then, but please remember that if there's parental alienation or abuse by proxy, then it's going to be very difficult, right? Because they're poisoning the child's mind at 10 years old. So you might have to wait, unfortunately, until the child is of age to really know the truth, because a lot of times these kids just are so confused. They can't figure it out. They'll just go with the abuser because they don't want to make waves with the abuser, because why would anyone? They don't want yelling, screaming, or complete silence, which is the other, end of the spectrum. So my heart's out to you, because I know that it is an uphill battle for you and your child.
Yeah. Okay, here's another one. Relocation. When someone's just, well, let's say not at the beginning of the divorce. Let's say there's already a custody agreement and somebody wants to relocate across the country, and another parent is fighting it. What are the chances of the other parent winning? Like, because we hear that relocations are very hard to get, especially if it's 50-50 everything, 50-50 physical custody and legal decision making.
Yes.
What have you seen in terms of that?
So, like everything else, it depends. If it's 50-50, yes, I agree. It's very hard to relocate, especially to a different country, you said?
No, just across the country.
The country. Well, it's sort of like a different country in
Yeah.
a sense. So if you have 50-50 and you want to do they call move away here, that's going to be hard to present to the court, because you're going to have to say why it's in the best interest of the child, okay, to move cross country, because obviously the other parent can't have 50-50, right? I mean, they can maybe in the summertime, right? Like 1 week here, 1 week there. But think about it. A judge is going to say, no way, unless the child's like, 12 years old and above, and be like, well, who's riding in the on the plane with the child, right? Because the child's not going to go by him or herself. So we find that they're very difficult. And usually what happens is the court will say that the parent has to go back and forth, not the child. So the child stays with one parent, the custodial parent, and then the other person, let's say the father gets a job in California and the mom's in New York, then the father has to go back and forth, not the child. And then
okay, so here, and I'm asking for a reason. I can't say why, but you can imagine. So let's say that the child does live with one parent more. They have more physical time with one parent, and that parent wants to move across the country, but the other parent really doesn't want, because then they'll never see the kid.
Right. Well, in your first example was 50-50.
Yeah.
So, and your example now is there's a custodial parent that has maybe like 80-20.
Right.
That will be a tiny bit easier, but again, what is the reason why? Is it job related? Is it family related? What is the reason why? Like I'm an attorney on a case actually in New York where the mom wants to move from Brooklyn to Nyack, which is like literally 35 minutes away, and we're having with that. So I'm telling you, it's not that easy. Okay. So before you move away, though, you should make the request to the court. Like some people move away, and that's like kidnapping your child. So do not do that. Okay. And I know some people are like, this is my strategy. Well, your strategy sucks, and you're going to have to bring the child back. So do not be doing things unilaterally, okay? Especially if there's joint legal custody. Now, there might not be joint legal custody. So custody is in two ways. There's legal custody and physical custody. Most courts give both parents joint custody, okay? So that's determining the education, health, welfare of the child. Okay. And then there's physical custody. So your first example was 50-50. That's going to be a hard move away. The second example, you said more custody. So I'm saying 80-20, and that's going to be a little bit easier. But what is the parent that's moving? How can they ensure that the other parent sees the child during the summer, other times of the year, et cetera, et cetera? See what
Let's say that parent, the one that wants to move away, has a history of not complying with a court order and has even interfered with the other parent's access time. Do you think a judge would be impacted by that if they see there's a history, so the other parent is fighting this long distance move, and there is a history of the the primary residential parent not, almost like trying to chip away at the time that the kid actually has access. So the other parent doesn't want to move away, hardly has any time, and it's being moved, and now it's like, what if they never see the kid when they move far away? Do you think a judge would be swayed by that?
I mean, I can't speak to every different case. It depends.
I know.
It depends on if the judge is in a good mood that day. It depends on, so many different factors, and every judge is different. Like I said before, judges in family court are subjective. There's no real rule of law. Okay, there's case law, there's some precedents, obviously, but family law is very subjective. Okay, so
Yeah.
it depends on the judge. My wonderful husband that always jumps on here is saying, is there a radius clause which has mileage limitations? I mean, yes, there's usually within the county. So we are literally in Los Angeles County. If you want to move your child to Orange County, which is literally an hour away, you'd have to ask. Now, sometimes it's within the state. Okay, that's obviously broader. So somebody from LA can go and live in Riverside with their child, and then they have to meet in the middle, or the parent that moved can say, okay, I'll bring the child more. So there are radius clauses, but to move a child across the country, I have seen it done, but it's a rare thing. And, you'd have to make a very good case, bring in the therapist, bring in child evaluation, bring in minors counsel, and all those people might not side with you, by the way. So take that into account too.
All right. Thanks. You're getting another one. I have no custody schedule. My ex refuses to share our son. Can I do an ex parte?
Wait, say that again. I'm sorry.
I have no custody schedule. My ex refuses to share our son. Can I do an ex parte?
You can do an ex parte, yes. It depends on where you are located. So a lot of time, judges don't want to do ex partes for custody. So what you can do is request it, and then they'll shorten the time. So if it's 45, 60 days, they might shorten the time and give you you'll be back in 15 days, for instance. And what they'll do is they'll just make you go into mediation with the other side to get some kind of custody sorted out. So you definitely can do an ex parte, but unless it's a real emergency, like the child is being physically abused, you have documented evidence, things of that nature, judges don't like emergency orders, and they don't make them. So because you're basically not giving the other side much notice. You're giving them 24 hours notice, and you're hopping into court. So you can do it. I'm not saying you can't, but I don't know necessarily if that's the strategy you want to implement so early on.
Okay. Here's something that actually came up today in our conversation. We were talking about a parenting plan, and someone was saying they have to be within 30 minutes. And we were saying 30 minutes could be it depends on the traffic. Wouldn't it just be miles versus minutes?
Yeah.
Do you ever see minutes written into a parenting plan versus miles? Okay. Yeah. All right.
If they have that, then the lawyers didn't do their jobs effectively. Because, to your point, I go between LA and our Orange County office, and God knows how long that could take. Some days it takes 3 hours.
Right.
Other days, 45 minutes. Other days I go with the train. Some days I like to drive. So yeah, you never want to put a time limit. You want to put mileage, or you want to put county. And some parenting plans, we put LA County, Orange County, Ventura County, Riverside County. Stuff like that to kind of broaden it a little bit. That means you can't go to San Diego with the child, but you can stay within the 4 counties. So just things of that nature you want to always be thinking about the parenting plan. Also, one other thing, I know are we almost done with time already?
Oh my God, I didn't even look. Yes.
With the parenting plan, make sure you put holidays in there. Make sure you put in, Mother's Day, Father's Day, holidays, child's birthday, Christmas, Hanukkah, Easter, whatever you celebrate, because you don't want it to be Christmas morning and Christmas Eve and you haven't seen your child. So make sure that you're very diligent. And we have a holiday schedule. You can usually download it and just kind of put in the holidays. Maybe you don't care about Easter, so don't put that in there. But you care about, like, you know, the 3-day holidays. So make sure you put that stuff in there. Yeah, so
Go ahead.
Go ahead. I just want to wrap this up. Are we wrapping up now?
Yeah, we should. There's like more stuff coming, but I don't think we can do it today.
Yeah.
But they could come next week to California and talk to us live.
Yes. So, so about next Thursday. So Lisa and I are co-hosting an event, a networking event, next Thursday at one of my favorite places that are actually my hangout. Okay, so y'all, if you don't like me, don't come here. Okay, on off days, because that's where I hang out with my friends and my husband. It's the Firefly in Studio City. It's this really cool little bar. It's next Thursday from 5:30 to 7. And then Friday, we have a lunch and learn at my office in Sherman Oaks from 12 to 2. Saturday, if you're in Orange County, we have drinks at the Waldorf Astoria, another one of my hangouts. Guys, if you don't like me, don't hang out with these places. And counsels usually don't like me, but my clients love me. And I just want to say, my husband's saying, focus on the best interest of the child. I love that. Set up a shared calendar, because the unhealthy spouse will constantly change the schedule based on their personal schedule. My husband is so wise, so wise. And that's it, I guess. So when are we doing another live? Like next month or something? Like,
well, I think what we should do is we should do a live when we're live.
Okay. I don't know necessarily how that's going to work, because we're going to have like 35 people there. So it's like,
we'll figure it out. It doesn't have to be that night. We'll figure it out, because we're gonna see you for a while.
Clients are coming, they don't want to be on the live. They'll be like, so there's it's confidentiality, but yes, we can get together.
We'll figure it out. We'll do just us without clients.
Yes. And anyway, thank you all for just listening to us. I hope it was helpful. I know Lisa's extremely passionate about what she does with the high conflict divorces. I'm extremely passionate about, serving the child first, the child's best interest. We are children focused at our firm. It is very important to me that the child is taken care of. Even sometimes I go against my clients because they want to be like, retaliate. And it's like, no, put the child first, And so we have the child's best interest at heart at all times. And, we represent high conflict divorces. We also do mediations, but we don't get as many of those as we'd like to get. We do a lot of narcissistic, abusive, toxic relationship. So I have, I basically work 24 hours, 7 days a week.
She does. She's called me at 5 in the morning.
No, I actually texted like, can I call you first?
And then he did.
If there's anything that, you want to ask us, you can obviously DM us after this. And we always run short on time, Lisa and I, because we're friends and we could jibber jabber all day.
Yes. All right. Well, so good to see you. Can't wait to see you next week. Thanks everyone for watching. Hopefully you got some good ideas regarding parenting plans, custody stuff, and more. And hopefully we'll meet some of you live. Oh, I know we'll meet some of you live next week. All right.
People already on here that are like, I'll see you next week.
Yep.
So I'm really excited.
Yeah.
Okay.
All right. Good. All right. See you soon, Padideh.
Okay. Bye.
Bye.